Hi, everyone, and welcome to the first day of the Criminalising Surrogacy conference. My name is Daisy Cheng, and for those of you who don't know me, I'm the Deputy Director at the Center for Medical Ethics and Law, which is one of the co-hosts of this event. So we have some really great speakers and panel chairs lined up over the next 2 days, and I really look forward to the discussions that we'll have on this very timely and important topic. So before I hand over to Jens and Lene to speak more about the project, I would just like to thank and acknowledge the Wayne Foundation for their continued and generous support of our center and our events. And I would also like to thank all of our speakers, many of whom traveled great distances to be here, and to all of you who are here, both in person and online, to participate in this event. So I now hand over to Jens, who is the great mastermind behind this wonderful project.
Use these amazing slides. So yes, it's also my great pleasure to welcome all of you here in my capacity as director of NORFAM, the Nordic Center for Comparative and International Family Law, is one of the co-organizers of this event. So you may ask yourself, what on earth is a Nordic Center doing in Hong Kong? Well, you know, you're pretty far from home, my friend. So let me just explain what NORFAM is and what NORFAM does. So NORFAM is a research center for comparative international research in the area of family law, but related areas including medical law and succession law. So we have directors of 5 Nordic countries, some of whom here in the room, and you might identify them later. But we also have members from almost all the law faculties in all the Nordic countries. So every institution where law is being taught, we do have a member. And we also have a number of corresponding members of international flavor. And the purpose of NORFAM is to promote scholarship, and especially Nordic scholarship. And we do so by creating networks and exchanges, particularly for our younger scholars, and by undertaking major comparative research, of which, of course, this is one. So some of these research projects are just inter-Nordic. So we're having one on the go on Nordic pension law, because you'd be surprised what happens to your pension when you move to one Nordic country from the other and then divorce. Most people are. Most people are surprised about their divorces anyway, but in pensions it's particularly interesting. Other research projects that we do have a broader scope. For example, we have one on assisted reproduction, parenthood, and gender discrimination on the run at the moment. And of course, we do have the one that brought us here together in Hong Kong, which we're organizing with our friends from the Center for Medical Ethics and Law here at HKU. So this is our reason for actually being here. So, but why surrogacy? And this is where I'm actually starting to change the slides, just in case you wondered. So obviously there are concerns about surrogacy globally, and apparently a controversial topic in many jurisdictions around the globe. And there are concerns, and they are to a certain extent justified, of course, about exploitation, about commodification of children and the female body, the sale of children, human dignity, and many related aspects. And there can be absolutely no doubt that these concerns are justified in very many cases, fully justified. But there can also be no doubt that there are some cases where they're not justified, and to the extent that these practices of surrogacy actually address these issues. And so that clearly required some in-depth research, which we start off with this. There we go. So apparently I'm not shouting loud enough. Right. So we actually had, as some of you may know, a very successful second cooperation actually with CMEL. The other one will not be mentioned, but I'm happy to do so later, but we won't distract from the current topic. So we already had a major comparative study that I co-organized together with Claire Fenton-Glynn, who's now sitting over there. We were both Cambridge people at the time, and now we've both moved to other pastures. So Claire's now at Monash, and of course I'm in Denmark. But that was a comparison of 21 jurisdictions around the globe. The book is actually, for the most part, still reasonably up to date. So please buy it and give us royalties, because for every book you buy, I can afford 12% of a beer. So that would be great. So there we are. This was then followed by a later study where we looked at surrogacy in Latin America. That book, if you Google it, is actually also available in Spanish as a free PDF. So if you're so inclined, by all means do. And what we took from these studies is a classification which Claire and I developed in the Locker, a cafe in Cambridge, very highly recommended. That classification still remains valid. And we grouped the approaches in the following way. slightly irritating because I'm always pointing here, expecting the screen to be there, but I'm not pointing at the faculty all the time. I'm trying to point at the screen. We had this basic categorization of 4 approaches once you start engaging with the topic of surrogacy as a legislature. So one of them is prohibitive, and that means just, we don't like it, we prohibit it. That seems to become more fashionable recently, as we will hear about today. Then we have what we call the tolerant approach, where we tolerate some approaches to surrogacy or some surrogacies, or at least the result of surrogacies. Namely the child, and we will allocate parenthood in some shape or form. Then we had what we call in terms the free market, where there's hardly any regulation, and it's left to the free market forces to decide what is happening. We also call that the wild, wild west. Of course, it also happens in the wild, wild east, so maybe that's not fair. And then we have what we call the regulatory approach, where there's a complete regulatory framework that actually deals with surrogacy and puts in place certain conditions for it to be successful or even possible. So, in the whole debate, of course, what about the best interests of the child? And that is the core issue, at least for most of us, I would think. And we'll hear about that quite a bit in this conference. But it was put most aptly, and this is why I have a long quote against my customs for slides by Mr. Justice Headley in the case called X and Y foreign surrogacy. And I will read it out in full because it really cuts to the heart of the matter. So what the court is required to do is to balance 2 competing and potentially irreconcilably conflicting concepts. Parliament is clearly entitled to legislate against commercial surrogacy and is clearly entitled to expect that the courts should implement that policy consideration in its decisions. Yet it's also recognized as the full rigor of that policy consideration will bear on one wholly unequipped to comprehend it, let alone deal with its consequences, i.e. the child concerned. That rigor must be mitigated by the application of a consideration of that child's welfare. That approach is both humane and intellectually coherent. And here comes the core sentence, hence the bold. The difficulty is that it is almost impossible to imagine a set of circumstances in which, by the time the case comes to the court, the welfare of any child, and particularly a foreign child, would not be gravely compromised, at the very least, by a refusal to make an order. And that, therefore, is that. So to summarize our research very briefly, and Claire may disagree, and she can do so publicly later, I think what our comparative studies have shown, but I don't think she disagrees actually, is that the prohibitive approach and the tolerant approach really have failed in achieving their policy aims. And that takes us here. So there are, of course, quite rightly, ethical concerns about surrogacy, and it's important we take them seriously. And of course, again, commodification, exploitation, sale of children, and so on. So the instinctive reaction for many people, therefore, and indeed governments, is that all surrogacies, or all commercial surrogacies, depending on which part of surrogacy you object to, must be prohibited, full stop, and then the world will be a better place. The result of such a prohibition, of course, is that surrogacies do not take place in those jurisdictions, particularly if the medical profession is forbidden from exercising them, and there will be consequences for the medical profession. So what we've seen from our studies, the result of such a prohibition or of only tolerating some forms of surrogacy is that citizens of these jurisdictions just go elsewhere for their surrogacies and then return home with a child. At which point we are then having problems with the recognition of legal parenthood or parentage, as the Americans would put it, always to the detriment of the best interest of the child. And therefore, what Justice Headley said applies in the quote, and this has also been confirmed inter alia by the European Court of Human Rights. Moreover, we could see that surrogacy essentially becomes a privilege of the wealthy, the heterosexual, and the male, because sperm always wins. And but the most crucial aspect of this is that we essentially just export our commodification, our exploitation to other jurisdictions where it happens, where it's beyond our control. And this is what triggered us to want to look more deeply into the criminalization of surrogacy. So given that there is virtually no chance that surrogacy will ever be forbidden across the globe in all jurisdictions, and that therefore we are fairly certain that surrogacies will always happen somewhere. We wanted to find out whether there's a rationale for prohibiting and criminalizing surrogacy on a national level, whether this criminalization, where it is in place, actually has the desired effects in terms of prevention and deterrence. Does this criminalization actually prevent exploitation and commodification globally seen? Or does it in fact promote the exploitation and commodification outside of the boundaries where the surrogacy is prohibited? In other words, does criminalization actually work? The book on this is going to be published by Edward Elgar Publishing. So those people who are contributing to this, you can see the raised finger. It's 2025. There will be deadlines. So keep your eyes peeled for that one. And it would be remiss of me not to mention the third International Surrogacy Forum, which Northam is organizing on yet another continent, this time in Cape Town, South Africa, together with the International Academy of Family Lawyers and the members of the family law section of the American Bar Association. You can see the delightful hotel here in the front. There's flyers, this is one that follows immediately after, but I'll finish up on this one. So in the very same hotel, there will be an amazing conference afterwards. So if you want to make the trip, make sure that you look at the booking page, because there will be reference to the annual conference that happens for the 27th time, I think, or the 29th, many times. It is the #1 family law conference in Africa, which happens immediately after ours. So it's 2 conferences with 1 travel, all in the President Hotel, which is pictured there. And then we're going to have our usual program. So you can see past surrogacy fora on the webpage there, and the bookings also there. So we will continue talking about surrogacy in the International Forum there. So now I've done my marketing bit. So welcome once again. Great to see you all here. And I will hand over to Lene to tell us about the criminalization.
Thank you. My name is Lene Wacher, Lentz, and I'm associate professor in criminal law at Aalborg University, and I work together with Jens on a daily basis. I also would like to bid you a very warm welcome to this conference. I've very much been looking forward to this conference. I think that criminalizing surrogacy is a very interesting topic. As a researcher in criminal law, I'm very interested in exploring when and why is criminalization involved, what is the reason behind the criminalization, and does it actually work? Throughout the conference, we will examine different jurisdictions, each with its own approach to criminalization. We will experience that some countries take a strict stance, while others have a more lenient approach. While I was working with the Danish chapter and also while reading some of the other chapters, I came to think of some criminal provisions as sort of sleeping criminalization. By that I mean that there are criminal provisions in place related to certain activities regarding surrogacy, and these provisions may have been in place for several years, but apparently there are no judgments in the matters. Why is that? Well, one could argue that people are just complying with these provisions, so that actually they work as a preventive measure. So, it works actually, but that's one perspective. Another answer could, of course, be that the criminal provisions are in place, but they are not being enforced. They're simply not being used. Well, if those provisions are not being enforced, you could ask, should they be removed, or are they just kept just in case? If a serious case occurs, they can be used, or should we really see these criminal provisions as symbolic legislation intended to reflect the legislator's stance on surrogacy? Well, all kinds of variations might occur. We will see that during the conference when we hear from each jurisdiction and the criminalization from each jurisdiction. Well, these were just a few initial thoughts from my side on criminalization. It will be so exciting together with you during this conference to explore the criminalization in each of our different jurisdictions. So let's have a great conference these 2 days.
Good morning, ladies and gentlemen, colleagues and guests. My name is Molly O'Donoghue, and I am a solicitor at Brodies LLP in Aberdeen, Scotland. It is a pleasure to be here today to discuss the work that Dr. Ilona Cairns and I have carried out on the criminalisation of surrogacy. In particular, I based my presentation today on the chapter that we contributed to the research handbook on surrogacy and the law, which was published earlier this year. This research was undertaken at the University of Aberdeen and funded by the Carnegie Trust. I'd just like to take a moment to thank Professor Scherpe for the kind invitation to speak today and for providing this opportunity to share our research with all of you. So before I delve into the main points of today's presentation, I'd like to provide just a bit of context on the focus of our work. Our research sought to provide a principled analysis of how the criminal law intersects with surrogacy, but instead of focusing on a single jurisdiction, we sought to uncover the underlying values that motivate states to criminalize surrogacy on a more conceptual level. My hope then is that this presentation will not only introduce you to the critical discussions that we will engage in over the next couple of days, but also complement the outstanding work of the other speakers here at the conference, whose contributions I've had the pleasure of reading. With that said, in typical legal fashion, I must outline a few exclusions. I won't be discussing any criminal activities like fraud, trafficking, or kidnapping that may arise in some surrogacy cases. These are serious crimes and naturally they must be prosecuted. Instead, we'll focus today on the domestic criminal offences specifically designed to regulate or prohibit surrogacy-related behaviours. So as will become clear in the discussions during this conference, many countries with specific surrogacy laws include criminal sanctions as part of their regulatory frameworks. While the motivations for criminalising surrogacy do differ globally, many of these laws share common assumptions. These are that criminal sanctions deter surrogacy, protect surrogates and children from harm, preserve human dignity, and safeguard the rights of women and children. And I encourage you to keep these in mind as we progress through today's presentation. So I'll begin with the premise that the criminal law has a unique capacity to label certain behaviours as morally wrong. For this reason, its application should be carefully limited, adhering to what we might call the wrongness constraint. And this stems from a core function of criminal law, which is to condemn and punish those who have done wrong. Criminalising conduct that's not inherently wrongful leads to unjust consequences and undermines the moral legitimacy of the law. The principles of criminalisation assist us in determining when behaviour is sufficiently wrongful and serve as a restraint on state power by limiting the circumstances under which the coercive force of the criminal law is applied to individuals. So to critically assess the justifications behind criminalising surrogacy, I'll today examine it today through three key Anglo-American principles of criminalisation. And these are the harm principle, legal paternalism, and legal moralism. So turning first to surrogacy and harm, and perhaps the most well-known principle of criminalisation is the harm principle, which at its core posits that the state can only justifiably restrict individual freedom to prevent non-consensual harm to others. And scholars have proposed various interpretations of the harm principle since its inception by J.S. Mill in 1859. But for our purposes today, we'll consider two versions of the harm principle identified by Duff and Marshall. And these are the harm prevention principle, which suggests that conduct should only be criminalised if doing so effectively prevents harm to others, and the harmful conduct principle, which contends that conduct should be criminalised if it is inherently harmful to others, regardless of whether criminalisation effectively prevents that harm. So the crucial question then is whether surrogacy is harmful enough to warrant criminal bans under the harm principle. While exploitation, trafficking, or assault are of course harmful, these problems do not inherently stem from surrogacy itself. They may be related to conditions surrounding some surrogacy arrangements, but if we focus on the core act of surrogacy, and that is carrying a child for somebody else, it's very difficult to argue that it is inherently harmful, especially because surrogacy arrangements should always be consensual and voluntary. So just as forced marriage or rape doesn't justify banning marriage or sex, instances of forced surrogacy doesn't justify a blanket ban on surrogacy. But let's consider then some harm-based arguments put forth in favor of criminalisation of surrogacy. In terms of harm to the surrogate, the primary concern raised by opponents revolves around the emotional pain the surrogates may experience after relinquishing a child, given the bond that can form during pregnancy. But this perspective assumes that all women bond with their fetuses in a uniform way, which empirical evidence does refute. The bond between a surrogate and a fetus varies widely depending on factors like the woman's age, attitude, and the circumstances of the arrangement. And research demonstrates that surrogates often experience lower maternal fetal attachment due to their distinct expectations, and many report positive experiences, including feelings of empowerment and appreciation of the friendships that they build along the way. Turning to potential harm to the children born through surrogacy, some argue that, like adopted children, they may face some psychological challenges, such as confusion about why their biological parents didn't keep them. But this view assumes that adoption is inherently harmful and also draws on very weak connections between surrogacy and harm. A more compelling argument in this context concerns the use of anonymous donor gametes in surrogacy, which could potentially infringe on a child's right, like the right to family life protected by the European Convention on Human Rights. Under a rights violation view of the harm principle, violating these rights could justify criminalisation. But while there might be grounds for criminal sanctions in cases involving anonymous donors, this doesn't mean that all surrogacy is inherently harmful, nor does it justify a complete blanket ban on surrogacy, either altruistic or commercial. So overall, our research suggested that there was very little evidence to support the idea that surrogacy itself is inherently harmful. And going back to the two harm principles I mentioned earlier, according to the harmful conduct principle, criminalization is only justified where there's clear harm to others, and surrogacy doesn't meet the standard in either physical or psychological terms. While some might argue that surrogacy can lead to indirect psychological harm, it often results in very positive outcomes, and that makes it hard to rely on the harm prevention principle. In fact, as has already been alluded to, the criminalization of surrogacy could unintentionally cause more harm, further weakening the case for criminalization based on harm prevention. So while surrogacy may involve risks, when considered in light of these principles, it's clear that the harm doesn't stem from surrogacy itself, but from surrounding conditions that can be regulated and dealt with separately. But there is an even bigger issue here, and that is that the harm principle simply cannot justify banning consensual surrogacy. So even if surrogacy did, for example, negatively affect the surrogate, a ban would have to rely on paternalism rather than the harm principle. So let's turn to this idea then. The principle of legal paternalism suggests that the state should criminalize behaviours that individuals have agreed to, including self-harm or harm imposed by others. And here consent plays a pivotal role, leading to a distinction between soft and hard paternalism. Soft paternalists contend that states should intervene only to ensure that individuals are fully informed and acting voluntarily, whereas in contrast, hard paternalists argue that the state should intervene to prevent harm, even if the individual is acting knowingly and voluntarily. So if surrogacy is consensual, then paternalism becomes a driving argument for restricting the surrogate's autonomy in this context. So those who argue against surrogacy on paternalistic grounds argue that surrogates may not be able to truly give informed consent before experiencing childbirth. They question whether the biological and psychological changes that occur during pregnancy might influence a surrogate's ability to make decisions. Now, while it's certainly true that pregnancy does involve significant changes, using these changes as a reason to limit women's choices is problematic because this view that women can't be trusted to make decisions about their own bodies echoes the kind of thinking that historically denied women basic rights in the workplace and under the law. A further argument that we hear in the commercial surrogacy context is that it exploits women, particularly those in financial hardship. There's a concern that commercial surrogacy causes women in poverty to feel pressured to become surrogates for financial reasons. But this raises an interesting question, and that is, why is surrogacy singled out as being exploitative when economic pressures affect many other jobs as well? If we're concerned that capitalism forces people into difficult work choices, why target surrogacy specifically for criminalization? And why not apply the same scrutiny to other forms of labour that involve economic necessity? Ultimately, the answer to these questions may be less about consent and more about deeper concerns over the commodification of women's bodies. If we're to understand why surrogacy is treated differently, we need to think about whether it's these moral considerations about dignity that are driving the push for criminalisation. Surrogacy can provide a pathway for individuals to become loving and caring parents. So not only does the argument for paternalistic intervention in commercial surrogacy lose strength due to a lack of evidence that it undermines consent any more than other potentially exploitative jobs, the case for intervening in any form of surrogacy, whether commercial or altruistic, falls short when we recognise that respecting autonomy does, in probably most cases, lead to tangible, positive outcomes. So the final principle that I'll discuss today, legal moralism, raises perhaps the most subjective debates, as it relies on moral judgments that vary widely across societies. Legal moralism is the idea that the law should intervene to prevent behaviour considered morally wrong, even if that behaviour does not cause any harm to others. And this approach stirs debate because it does assume that society has a unified understanding of what constitutes immorality. While some acts, like murder or rape, are universally seen as immoral and are therefore rightly criminalised, not all behaviours are so clear-cut. Take, for example, cheating in a relationship. Most would agree it's morally wrong, but it's not something that's criminalised. And this is where we see the tension between moral standards and liberal values like privacy, autonomy, and liberty. So critics of surrogacy argue that it commodifies women and children, reducing women to mere incubators and treating children like objects. These anti-commodification arguments draw heavily on concerns about human dignity, which is a core value in many countries, and hold that certain things like human reproduction should never be bought or sold. Another central concern is that surrogacy undermines traditional family values by interfering with the natural union of husband and wife, particularly through separating genetic, gestational, and social parenting roles. This concern is often rooted in religious and conservative views that surrogacy threatens the natural link between pregnancy and motherhood. But reproductive technologies like surrogacy often support traditional family structures, helping heterosexual couples with fertility issues to have children. Also, the evolving human rights norms around equality and diversity are reshaping family laws, as evidenced by the UK's allowance for single individuals to seek parental orders after surrogacy. With widespread societal acceptance of non-traditional families, arguments that surrogacy harms family values do struggle to justify its prohibition. And it's essential to question the validity of these moral arguments and whether they should be used to justify criminal sanctions. For one, many of the concerns about commodification and exploitation are often overstated in that surrogacy does not inevitably lead to a transaction-like perception of parenthood, and nor does it inherently compromise familial bonds. But while moral arguments may resonate on a personal level, they lack the weight needed to justify criminal legal intervention. Legal moralism's subjective nature makes it difficult to build a coherent legal framework solely on moral grounds. If the law were to reflect every moral concern, it would infringe upon individual freedoms, especially in areas like reproductive rights, where moral opinions do differ widely. So from a practical perspective then, even if we could justify criminalising surrogacy by applying the individual principles or indeed a combination of them, the reality is that criminal law often falls short as an effective regulatory tool in this context. In many jurisdictions, decisions to outlaw surrogacy or related activities are based on the idea that criminal sanctions will discourage people from pursuing surrogacy. But while it's true that criminal sanctions can make it harder for people to find surrogates within their own countries, the demand for surrogacy is far from declining. The rarity of prosecutions and convictions for surrogacy-related offences further highlight the criminal law's ineffectiveness here. Some might argue that the lack of prosecutions indicates that the laws are effectively deterring people from engaging in surrogacy, but the evidence suggests that in reality, when surrogacy is banned domestically, many couples simply turn to countries where surrogacy is unregulated, leading to risks for the surrogates. In places where surrogacy tourism is common, surrogates often face poor working conditions, low pay, and physical or psychological harm. So criminalising surrogacy does not reduce its prevalence, but instead pushes it underground or drives it abroad, often leading to greater exploitation and harm. And if the goal of criminalising surrogacy is to protect surrogates from exploitation, then pushing the practice into unregulated international markets does the opposite. And in light of this, the costs of criminalisation, both in terms of risk to surrogates and the ineffectiveness of the laws themselves, outweigh any perceived benefits. There are further costs to criminalisation rather than just an increased risk of harm. Criminal bans make it significantly harder for individuals with infertility to have a child with a genetic connection to at least one parent and to raise that child in a loving and secure environment. These restrictions arguably infringe upon fundamental rights like autonomy, privacy, reproductive freedom, and even the right to contract and work. For same-sex couples, surrogacy is often a key pathway to parenthood. By prohibiting it, the state may reinforce heterosexual models of family structure, whereas in contrast, allowing surrogacy sends a strong message that the state supports diverse family forms, recognizing the rights of all people to build a family in ways that align with their values and desires. And the effects of criminalization extend to the children born through surrogacy, particularly in cases of cross-border arrangements. In countries where the legal landscape surrounding surrogacy is unclear, families often face prolonged and complex legal battles over parentage. This uncertainty can harm a child's sense of identity, as being legally recognized as a parent impacts not just social status, but also the child's personal development. So before I wrap up today, let's take a moment to reconsider the key assumptions I mentioned earlier. That criminal sanctions deter surrogacy, protect surrogates and children from harm, preserve human dignity, and safeguard the rights of women and children. So are these beliefs about the role of criminal law in regulating surrogacy valid and true? Based on our research, the answer was a definitive no. So where does this leave us? Many countries introduced criminal sanctions for surrogacy when the legal landscape was far less developed, and without much debate on whether the criminal law was the right tool for regulating it. And now, with decades of research to draw from, we can confidently say that using criminal law to govern surrogacy isn't just unprincipled, but it is ineffective. The starting point is straightforward. The state should hold itself to a higher standard when it comes to criminalization compared to other forms of regulation. But what we found is that this stricter standard isn't applied when it comes to surrogacy. The core principles that normally guide the use of the criminal law don't offer sound justifications for criminalizing surrogacy, whether it's altruistic or commercial. And even if they did, the negative consequences of criminalization outweigh the potential benefits. Criminal sanctions oversimplify the issue. They stigmatize surrogates and fail to address the legitimate concerns that people do have about surrogacy. So it's time to rethink how we approach its regulation. By focusing on nuanced evidence-based regulation rather than blanket criminalization, we can aim to protect the rights and dignity of all those involved. Thank you very much for your attention, and I look forward to hearing from the rest of the speakers.
Well, thank you all for coming, and I'm very grateful for this opportunity to be among such esteemed academics. Allow me to first introduce our speakers before we go on to the presentations. First, Professor Esther Farnós Amorós, who is an associate professor at the civil law at the University of Pompeu Fabra. She has been a visiting lecturer at the Autonomous University of Madrid and the University of Girona, where she is part of the Institute of European and Comparative Private Law. Her main research interests lie in the fields of law of persons and the family, and where she has mainly explored topics such as family self-determination, parenthood, with special attention to parenthood resulting from access to reproductive technologies. She is a member of the Codification Committee of Catalonia, the Catalan committee in charge of developing the Organic Act of Euthanasia and Bioethics Committee of Catalonia. As a national expert, she has collaborated on several reports and comparative works on grounds of divorce, surrogacy, and parenthood. And I suppose maybe at the same time, I can introduce Professor Raquel Montana Fernandez, who's a professor of criminal law at the University of Pompeu Fabra as well. Her main research interests currently are crimes against family relationships and gender-based crimes, especially crimes of sexual violence, which are also the subjects on which she is currently lecturing at both undergraduate and postgraduate studies. She is also currently a member of 2 research groups specializing in economic criminal law and the sub-editor of a journal specialized in criminal compliance. And then finally, Professor Rute Teixeira, Pedro? Yeah, I'm sorry, I do my best. Professor Teixeira is Associate Professor at the Faculty of Law of the University of Porto. She is currently its Vice Dean and Vice President of the respective Scientific Council. She is a researcher at the Interdisciplinary Research Center on Justice. Professor Teixeira is a corresponding member of the Cambridge Family Law Center, the Medical Law and Family Law Centers of the University of Coimbra, the European Law Institute, and associate of the International Society of Family Law, among other national and foreign entities. Among her more than 90 publications, there are 7 books, more than 70 chapters in books and articles, and in the national and international magazines, 4 books as a coordinator. Where do you find the time? and she was published in Portuguese, English, Spanish, and Italian. I'm limited to English, so I'm impressed. Okay, please.
Thank you very much. Well, it's a pleasure to be part of this conference in the University of Hong Kong. We wish to thank the organizers and especially Professor Jens Scherpe for allowing us to be part of this whole project. Following our report, we will briefly present the Spanish approach to surrogacy in order to reflect on if there is something such as criminal surrogacy in our country. In the last years, and especially since 2016, probably because of the boom in international surrogacy, Spanish media have reported on the criminal prosecution of several cases, which a priori could have something to do with domestic surrogacy. However, there is no information on the legal development of such proceedings. The impossibility of accessing pretrial proceedings, as they are not included in legal databases, is therefore one of the main methodological challenges of our report. Before we go deep into the legal framework, we wish to make some preliminary remarks. As my colleague will develop, our starting point is the lack of criminal convictions in relation to surrogacy cases by Spanish courts. In this context, our preliminary assumption is that this absence can be explained by the existence of what we call a soft prohibition, and also by the dynamics of the civil jurisdiction itself. So, if the civil jurisdiction already recognized in one way or another parenthood resulting from international surrogacy arrangements and other related effects, as we will point out later on, it's reasonable for criminal ultima ratio to remain on the sidelines, except for grave cases. This is cases where there is a clear situation of exploitation or coercion. To continue with, we will present the Spanish legal framework regarding both domestic and cross-border surrogacy. As per domestic surrogacy, surrogacy arrangements in Spain are considered fully null and void, irrespective whether they are entered into an altruistic or commercial basis. This is explicitly stated in Article 10 of the Law on Assisted Reproductive Technologies from 2006, which continues the same line that the former Act on Assisted Reproductive Technologies from 1988. So these contracts can be considered according to the Spanish Civil Code, contracts with no full purpose. The immediate consequence of this nullity is that the traditional Roman law principle, mater semper certa est, applies, and therefore the mother is the woman who gave birth to the child. This is explicitly stated in the mentioned Article 10(2). However, this same article, Article 10 of the Law on Assisted Reproductive Technologies, allows that the biological father is considered the legal father according to the general paternity rules. Following the categorization proposed by Professors Scherpe, Lene, and Cheng in 2019, the Spanish approach to surrogacy could be considered prohibitive. However, we must stress that the consequence in Spain for both commercial and altruistic surrogacy is not a criminal one, but a civil one, the nullity of the arrangement. This is definitely not the strongest possible message about a state's aversion to surrogacy, and probably this has consequences in criminal terms. In a global world, one of the main consequences of the described prohibitive approach, although soft, is that Spanish couples and single persons who wish to have children in this way also travel to other countries where surrogacy is explicitly permitted or simply tolerated. Therefore, at the beginning of the 21st century, there was a clear boom in access to international surrogacy by Spanish intended parents, although there is a lack of reliable data on the number of surrogacy arrangements performed abroad by Spanish citizens. In the absence of a domestic legislative response to the topic, parenthood resulting from cross-border surrogacy has been established by administrative and judicial authorities on a case-by-case basis, which has led to great legal uncertainty. Being surrogacy not permitted at domestic level, automatic recognition of parenthood regarding the intended parents is possible when parenthood is established in a foreign court decision. Foreign birth certificates or declarations of birth naming the intended parent or parents as legal parents cannot be recognized per se because only judicial decisions are granted automatic recognition as long as they meet the other requirements imposed by an order issued in 2010 by the General Board of Registers and Notaries, which is an administrative body depending on the Ministry of Justice. This was an administrative response. It's important to stress this, as this was not a legal response to the ever-increasing number of Spanish couples and single persons going abroad in order to access surrogacy. The requirement of a court decision from a competent court in the country where the child was born is apparently imposed to ascertain that international child trafficking is not involved, that the principle of the best interest of the child is respected, and that the capacity of the surrogate and the freedom and revocability of her consent are guaranteed. For this order to be applied, there must also exist at least one intended parent who is Spanish and one intended father who keeps a genetic link with the child, who can bring afterwards a paternity claim according to the general paternity rules to which I referred before. But what happens when the former requirements cannot be met? For instance, because there is no foreign court decision to be recognized in the destination country, or there is no a genetic link between an intended father and the child. In these cases, Spanish courts have still allowed to award parenthood to the intended parents by means of adoption, or exceptionally, when adoption is not possible by means of possession of a status. In consequence, parenthood resulting from international surrogacy is, except for anecdotal cases, sooner or later established by Spanish authorities. Beyond parenthood, Spanish intended parents have also been granted paternity or maternity leave. And furthermore, the child's place of birth has even been modified in the civil registry in order they can appear in the official documents as born in Spain, in analogy with international adoption. This has been recently confirmed by a Supreme Court decision. Although Spanish Supreme Court judgments from 2014 and 2022 considered that commercial surrogacy is contrary to Spanish law of the Republic, as it violates the dignity of the surrogate woman and the child. In a landmark case from 2022, the second one I mentioned, the Spanish Supreme Court referred a single intended mother who had accessed surrogacy in Tabasco, Mexico, with donated eggs to adoption, even when she exceeded the maximum age required by the Spanish legislation for adopting a child. At the time of the judgment, the child was 7 years old and had lived all their life with the intended mother and her parents. The case is particularly shocking as the judgment quotes an extensive part of the surrogacy arrangement, from which can be inferred that it was clearly exploitative for the surrogate. Thus, it contained contractual clauses which precluded any future relationship between the surrogate and the child, imposed her a cesarean section unless the doctor recommended her a vaginal birth, or precluded her from being reimbursed in case she could not get pregnant after 2 or more in vitro fertilization treatments. To put an end to this first part of our presentation, it must be stressed that except for blatant cases where parenthood cannot be recognized and resort to adoption or possession of a status is neither possible, the establishment of parenthood resulting from cross-border surrogacy has not been problematic in practice in Spain. As a last resort, when or while parenthood cannot be established, Spanish intended parents can still be considered de facto carers, temporary foster parents, or even legal guardians. Ultimately, if the child has been under their legal guardianship for more than 1 year, it would even be possible that this situation turn it into an adoption with no need of a previous proposal by the public administration. Now it's time to give the floor to the expert in Spanish criminal law, my partner in crime, Raquel Montaner. So thank you very much for your attention.
Thank you, Esther. As you know, it's a pleasure to be your partner in crime. I just want to say that I'm very grateful to be here, sharing some ideas about our research with you, and to continue with our presentation, I will focus on the criminal perspective of surrogacy in Spain. Although since last year, surrogacy is considered by law as an expression of violence against women and a serious form of reproductive violence, this statement has not had consequences at the criminal level so far. Likewise, Spanish criminal courts have not discussed surrogacy either. In fact, not even the so-called baby stealing cases, which took place in Spain during the 60s and 90s, have had much significance in case law due to the crime's statute of limitations. Referring to some existing means in positive law, despite the fact that there is no specific offense of surrogacy according to the current criminal regulation, it could be possible to link surrogacy to some offenses. Firstly, the offense of simulation of childbirth which consists of pretending a childbirth, and also the misrepresentation of parenthood, which consists of hiding or delivering a person under 18 years to third parties for the purpose of altering or modifying their parent. Secondly, the child selling offense punishes those who, by means of financial compensation, hand over a child, circumventing the legal procedures of care, fostering, or adoption for the purpose of establishing a relationship analogous to that of parent. The point is that these offenses are not originally designed to punish surrogacy. In relation to simulation of childbirth and misrepresentation of parenthood, the majority of Spanish scholars understand that the legal asset protected is parenthood resulting from birth. The offense of child selling refers to cases where a child is handed over circumventing the legal procedures. From this perspective, the aim of the offense could be to reinforce through criminal law the civil legal system established to ensure parenthood. However, in order to avoid such a formalistic conception of the offense, and taking into account the existence of the element of financial compensation, it is understood that the offense also affects the dignity of the child, who is treated as a mere commercial object. When surrogacy can be associated with exploitation scenarios, the crime of human trafficking could also be taken into account. Its protected legal asset are the dignity and freedom of human beings. The actions of this serious offense must be undertaken for specific purposes. As reproductive exploitation is not among these purposes, some authors argue for the need to include recruitment for surrogacy between the different forms of exploitation. In Spain, we also don't have any case law of human trafficking related to surrogacy situations. As long as there is not a single criminal case today specifically dealing with surrogacy, our research results must be understood as exclusively referred to offenses against family relationships that have actually been prosecuted by the Spanish criminal courts. The first aspect is referred to the criminal actors. With regard to the simulation of childbirth, some Spanish scholars understand that only the woman who simulated childbirth could be the perpetrator. However, according to some other opinions, this offense does not require that the previous pregnancy or the physiological process of childbirth has been faked. Therefore, other possible subjects could be considered, such as the partner of the woman who simulated childbirth, who registers the child as his own, or the doctor who certifies a birth but attributes parenthood to people different from the newborn's parents. In cases of misrepresentation of parenthood, both legal parents and others involved in the hiding or delivery can also be punished. In cases of child selling, the person receiving the child and the intermediary can be punished with the same penalty as crimes authors. Well, the 2 points. Concerning agents and intermediaries, there is an express provision for the criminal responsibility in the field of child selling crime. However, there are currently no criminal judgments for intermediaries in surrogacy. There are no convictions of intermediary surrogacy companies as legal persons either. We also want to mention that since 2017, at least 10 civil courts have sanctioned intermediary companies for breach of contract. One of these companies is Subrogalia, a Spanish company that provided legal advice in international surrogacy cases. Although at first sight it can be seen somewhat inconsistent that civil courts decide on the remedies attached to the breach of contract when the Spanish law clearly states the full nullity of surrogacy arrangements, this case law relies on the fact that it's not the surrogacy arrangement in itself what it's under discussion, but the contract for related services. Since 2023, the advertising of commercial surrogacy is an illegal activity. According to the current regulation, public institutions must promote public information on the illegality of surrogacy and the nullity of these agreements, as well as on the prohibition to promote commercial surrogacy. Regarding health and health professionals, at an administrative level, the practice of surrogacy by them could be considered a very serious infringement. The sanction to the professionals practicing surrogacy in Spain is a fine between 10,000 RAN and 1 million euro, as well as the closing down of the center where it was carried out. At the criminal level, in addition to the corresponding prison sentence, educators, practitioners, authorities, or public officials who, in the exercise of their profession or position, have committed some of the offences previously mentioned, shall be sentenced to a special disbarment to hold public employment or position, professional trade, from 2 to 6 years. Finally, we would like to refer to jurisdiction in the prosecution of these crimes. In particular, the child selling regulation states that person who receives the child and the intermediary shall be punished with the same sanction, even if the child's delivery took place in a foreign country. Although this last mention could be interpreted in the sense that Spanish courts can know about these criminal acts when performed abroad in a kind of universal jurisdiction, this is not its real meaning. Rather, the point is that even if the conduct or part of the conduct is undertaken out of Spain, the criminal relevance does not exist until a relationship analogous to parenthood is established or intended to be established in Spain. And this will take place when the Spanish authorities are approached to register the child. This is precisely what happens in cases of international surrogacy. But even having this legal possibility, there are no criminal convictions on surrogacy. It should also be noted that according to the law, the general rule is the territorial principle. To this point, despite the fact that the Spanish jurisdiction is only competent to know about offences committed in the Spanish territory, there are some situations in which this territorial jurisdiction can be extended. For instance, in case of crimes against humanity, such as genocide or terrorism, but also crimes related to prostitution or drug trafficking. None of the offenses listed refers to crimes against family relationship, nor to surrogacy either. Finally, I will briefly refer to our preliminary conclusions. The first one. Several legal reforms based on the idea that surrogacy is an expression of violence against women and a serious form of reproductive violence have been recently introduced in Spain. This punitive reaction is not only in tension with the lack of criminal convictions and the recognition of parenthood and other related effects in the majority cases of cross-border surrogacy, but also with recent sociological data on the Spanish public opinion on surrogacy. The second one. Although there is no specific crime offense for surrogacy, some cases, especially those of commercial surrogacy, could be punishable under current criminal law. However, from the analysis of the case law, it could be said that the Spanish criminal justice system is not interested in its prosecution. Ultimately, the criminalization of surrogacy should require a prior political discussion on what should be the new asset to be criminally protected, as distinct from that which is protected by existing criminal law. The last one. The Spanish authorities, despite considering international surrogacy arrangements contrary to the Spanish ordre public, usually grant them parenthood effects based on the best interests of the child. Except for serious cases of mistreatment or neglect, children conceived through international surrogacy can peacefully live in Spain where their intended parents. Thank you for your attention. It will be a pleasure to discuss. Okay, thank you.
In Portugal, specific legal rules around surrogacy were introduced very recently. Law number 25, dated 2016, which amended the medically assisted procreation law, created a legal framework for surrogacy in Portugal in 2016. So Portugal adopts a regulatory approach on surrogacy. Diversely, according to the first version of the medically assisted procreation law, which dates back to 2006, although the use of medically assisted techniques to procreate was authorized, surrogacy was not permitted in any circumstances. Criminal penalties apply to anyone who concluded or promoted surrogacy agreements either directly or indirectly. In 2016, a change in the approach to surrogacy agreements occurred. The valid conclusion of surrogacy contracts, I will say contracts because Portuguese law qualifies these agreements as contracts. So the valid conclusion of surrogacy contracts was accepted in some specific circumstances, provided multiple and cumulative requirements were met. The path that has started with the entry into force of the law dated 2016, it is not a linear path. It is a path made of breakthroughs and setbacks. In fact, on 24th April 2018, the Portuguese Constitutional Court handed down a decision in which, while recognizing that the Portuguese model of surrogacy per se was not incompatible in principle with the Constitution, the court stated that certain aspects of the newly introduced solutions violated constitutional provisions. So, as a consequence, the court declared with general binding force the unconstitutionality of 8 of 12 paragraphs of the article that governs surrogacy, Article 8. It still is the Article 8. One of the major issues that Portuguese Constitutional Court criticized in the 2016 regime was the irrevocability of the consent of the surrogate after the beginning of the medically assisted procreation. The Portuguese Constitutional Court considered that the surrogate should have the right to revoke her consent until the moment she delivers the baby to the commissioning parents, as the only means to safeguard the continuity of her consent for the entire duration of the surrogacy contract. The declaration of unconstitutionality foreclosed the possibility of validly concluding such agreements in Portugal, but only until the parliamentary legislator could establish a constitutional adequate regime, as it was stressed by the Portuguese Constitutional Court. As a matter of fact, the court explicitly stated that surrogacy itself does not give rise to the violation of human dignity of the unborn child or of the surrogate. According to the court, not only there is no incompatibility with the Constitution, but also surrogacy has a positive constitutional relevance, as its permission corresponds to an option of the legislator that, besides being not arbitrary, favors constitutionally protected interests as such should not be dismissed without strong reasons. Furthermore, the Constitutional Court expressed its approval of what was called Portuguese model of surrogacy, which was characterized by the following elements: the subsidiarity, the exceptional and purely gestational nature, the demand for autonomous consent of the involved parties to guarantee their free and sustained consent, the formalization of the agreement by means of a written and non-commercial contract, which must be previously authorized by a competent authority. So the Parliament reshaped the legal framework of surrogacy and approved the Law 90/2021, dated 16 December 2021. This law came into force on the 1st of January 2022. However, according to Article 5 of the same law, the government should have approved within 30 days after the publication of the law the respective regulations. The deadline for approval of a specific regulatory decree was the 15th January 2022. That did not happen. And more than almost 3 years have already elapsed since that limit. The lack of regulation makes the recourse to surrogacy in Portugal unfeasible. Therefore, at this moment, there is a marked difference between what is stated in the law, that is in force, and the practical reality. Consequently, at this moment, it is not possible to conclude a valid surrogacy contract in Portugal, even if law admits it. It's a strange situation. Being that said, from this point on, it will be considered the regime adopted by the Law 90/2021. The recourse to surrogacy continues to be accepted on an exceptional basis. In cases of absence of uterus, injury or disease of this organ, or other clinical situation that absolutely and definitely prevents the woman from becoming pregnant. In addition to the verifying of one of these situations, it is required that surrogacy contract must necessarily not be commercial. Portuguese surrogacy model is presented in Portugal as an altruistic one. This is a central axis of the Portuguese regime, as was stated in the decision of the Portuguese Constitutional Court that I've mentioned before. Law only allows the payment to the surrogate of the amount corresponding to the expenses arising from the health monitoring actually provided, including those related to transport, if they are duly certified in a specific document. As those expenses may be paid, Jens, Scherpe, and Claire Fenton characterize and categorize the Portuguese regime as a compensated regime and not as a truly altruistic one. Additionally, law requires that the contract is concluded in writing. Furthermore, prior authorization from the National Council for Medical Assisted Procreation is required. In addition, in case of surrogacy, gametes from at least one of the members of the intended parents couple must always be used. So the medically assisted procreation can only be partially heterologous. Additionally, the surrogate cannot, under no circumstances, be the donor of any oocytes used in the specific surrogacy procedure. No genetic connection may exist between the surrogate and the baby. Thus, only gestational surrogacy is allowed. It is also provided that between the parties, there cannot be a relationship of economic subordination, notably of a labor nature. One of the major novelties of law dated 2021 is that the surrogate is now recognized the right to freely revoke her consent until the moment the child born as a result of surrogacy is registered. That possibility of revocation has a significant impact in the allocation of legal parenthood at the time of the birth. In fact, the terms of establishment will be necessarily dependent on the exercise or the non-exercise by the surrogate of her right to revoke her consent. And that revocation can occur until the child is registered, according to the solution introduced in law dated 2021. If the surrogate does not revoke her consent, both intended parents will be recognized as legal parents of the child. Upon the inscription in the civil register, the law recognized that effect without the need of the performance of further legal acts or the fulfillment of additional requirements. There is no parental order or any process similar to the adoption process. If the surrogate revokes her consent, she will be the mother of the child, and the legal rules inserted in Portuguese Civil Code will apply to the establishment of paternity. In order to reinforce compliance with the conditions that Portuguese medically assisted law demands, criminal and administrative penalties may apply. There is a special chapter of the medical procreation law dedicated to criminal liability, administrative fines, and additional accessory penalties that may be applied when there is one of a set of specifically legally demarcated behaviors that represent violation of its provisions regarding the use of medically assisted procreation techniques. This chapter has not been amended in 2021. It remains unchanged. Only Article 39 specifically concerns surrogacy. According to that provision, any breach of a legal provision concerning surrogacy may lead to the application of criminal penalties, which differ, as will be explained, depending on the person who breaches the law, whether if the agent is the commissioned parent, the surrogate, or another person. And it depends also on the type of behavior perpetrated by him or her. As for the surrogates, the medically assisted procreation law provides that they can be held criminally liable in two kinds of situations. If this, on one hand, if the surrogacy contract is of a commercial nature, the surrogate who have entered into it may face a criminal fine up to 240 days. Diversely, if the surrogacy contract is altruistic, but any further condition, legal condition, is not fulfilled, surrogate may be held criminally responsible and criminal fine up to 120 days may be applied. I must explain that a criminal fine is defined considering a number of days that is defined by the court based on the fault of the agent and the prevention goals that should be pursued through the application of that penalty. For that purpose, the court shall take into account all circumstances which are in favor of the agent or against him or her. Each day of fine corresponds to an amount between €5 and €500, which the court sets according to the economic and financial situation of the person sentenced and his her personal expenses. In relation to intended parents, the medically assisted procreation law also provides for criminal sanctions in certain circumstances. Again, as it occurs regarding the surrogate's criminal responsibility, the law distinguishes the violation of the contract's altruistic nature requirement from the violation of other legal requirements. If the surrogacy contract is of a commercial nature, the intended parents may face either imprisonment up to 2 years or be liable to pay a criminal fine of up to 240 days. Diversely, if the surrogacy contract is altruistic, but one of the other legal conditions is not fulfilled, the intended parents may face either a prison sentence of up to 1 year or may be liable to pay a criminal fine of up to 120 days. Consider the information that I have just provided, a simple comparison to the penalties that the surrogate pays allows us to conclude that the criminal penalties applicable to the intended parents are much more severe than those which are applicable to the surrogate. Portuguese medically assisted procreation law does not assign any particular rule for mediators or agencies in the Portuguese legal system. Even if there are no special rules or regulations concerning their involvement in the surrogacy process, they will incur in criminal responsibility if they adopt any of the behaviors stated in the law as criminally punishable. In fact, any person who by any direct or indirect means, including by direct invitation or through an intermediary person or public announcement, promotes the conclusion of surrogacy contract outside legal limits, shall be punished with a prison sentence of up to 2 years. Additionally, any person who in any circumstance derives economic benefit from the conclusion of a surrogacy contract or from the promotion thereof by any means shall be punished with a prison sentence of up to 5 years. Professionals who provide medical and health care may incur criminal liability to the extent that they have carried out one of the acts just outlined previously. Thus, if one of these professionals promotes, then by any direct or indirect means, the conclusion of surrogacy contracts outside the cases permitted by law, they may be punished with prison sentence of up to 2 years. Likewise, if a medical health care professional under any circumstances derives economic benefits from the conclusion of surrogacy contracts, he or she shall be punished with a prison sentence up to 5 years. Furthermore, if medically assisted procreation techniques, including those carried out in surrogacy situations, are performed outside of an authorized center, that may lead to the conviction to a prison sentence of up to 3 years. Criminal sanctions are also legally provided for those who carry out reproductive cloning, choice of non-medical characteristics, creation of chimeras or hybrids, misuse of embryos, non-consented collection and use of gametes, post-mortem procreation without duly consent, and the violation of the duty of secrecy and confidentiality. Nonetheless, any of these crimes can occur in the context of use of medically assisted procreation techniques, even without surrogacy taking place. Furthermore, if the conduct of the professional produces the breach of a legal duty that applies to the performance of the corresponding profession, as it happens with the medical profession, as it is recognized as a professional association that supervises the respective exercise, the professional may also incur in professionally disciplinary liability. They may face disbarment. Legal persons and similar entities are criminally responsible in general terms applicable in the Portuguese legal system for the crimes that I have just mentioned. All these criminal penalties may apply even if the intended result is not achieved. Indeed, even an attempt to engage in that kind of conduct may be a criminal offense. In addition to the criminal penalties, administrative fines may also apply in 4 situations that are enunciated in the PowerPoint. To finish my presentation, I would like to say that, as it can be inferred from my brief presentation, criminal liability only applies to respond to very serious behaviors that affect essential values of the legal system, and as long as they are typified by law. Criminal law sanctions are designed as tools to reinforce the legal framework of surrogacy, especially the most significant traits of the regime. As a consequence, more severe sanctions apply when there is a breach of the altruistic nature of the agreement than when other legal requirements are violated. This strengthens the essentiality of that element that is central in the Portuguese model, as is stressed by the Portuguese Constitutional Court. At the moment, there are no convictions by Portuguese courts, there are no case law regarding surrogacy, and the consequence, there is no data about the effectiveness of these sanctions. Thank you very much for your attention.
Good morning. Welcome to the second session, where we will be traveling, remaining in Europe, traveling north to Denmark and Finland. I'm particularly excited, as I've just been told by Jens, that these countries adopt what he called a hardcore feminist approach. So listen out for clues. I'll very quickly introduce myself. My name is Josh. I'm a barrister in Hong Kong. I had the great fortune of being taught family law by Jens in another life, and I practice here. And in the course of my practice, I am sometimes asked to advise on surrogacy arrangements, almost always the same questions, namely, how can I become a parent, and how can I regularize my immigration status? Of course, because all of that is completely illegal, I can't comment in any way. But that is one of the problems of a global offence. In any event, allow me to move on much more importantly to our 3 speakers in this second session. First, we have Professor Lene Wacher Lentz, which I've almost certainly mispronounced. Professor Lentz is an associate professor of criminal law and procedure at Aalborg University. She is a former prosecutor and wrote a PhD on the legal framework of police conducting secret investigations on the internet, combining her practical experience with a theoretical approach. Her research interests are diverse and include new perspectives on criminalisation, such as those related to surrogacy, which raise important questions about the role of the criminal code in social matters. Then we have Dr. Sara Silvola. Dr. Silvola is adjunct professor in medical and bio law at the University of Helsinki. She has a doctorate in law from that university and a master's degree in medical ethics and law from the University of London King's College. She presently works as a senior ministerial advisor at the Ministry of Justice in Finland, but I've been told that all views are her own and nothing is to be attributed to said Ministry of Justice or injustice, as it may come to be seen. She's a member of the advisory board of the Nordic Centre for Comparative and International Family Law, or NORFAM, a Finnish member of the Academic Network on Family Law in Europe, FLUR, the Commission on European Family Law, CEFL, and the Nordic Expert Group of Family Law. She has written extensively in medical and family law and led several legislative projects in family and succession law. She is the main author of the report on allowing non-commercial surrogacy in Finland, published by the Ministry of Justice in 2023. And last but not least, Professor Katja Karjalainen, a professor of law and welfare at the University of Lapland and a lecturer at the University of Eastern Finland. Dr. Karjalainen obtained her PhD in private international law and in comparative law in 2016 from the University of Helsinki. She is a docent, doctor, I suspect, in private law, private international law at the University of Helsinki, and a co-director of the Nordic Centre for Comparative and International Family Law, and a member of the Finnish branch of International Law Association. Her research and teaching activities have addressed non-discrimination law and family law instruments of the Hague Conference on Private International Law and the European Union. She is a Finnish PI of the project Art Equal, which stands for Assisted Reproductive Technology and Equality at Aalborg University. Without any further ado, I am delighted to invite Professor Lentz to begin taking us to Denmark.
Thank you very much for this presentation. Well, I will give you the Danish report on criminalizing surrogacy according to the Danish legislation. So I have this agenda for my presentation. First, I will give you an overview of the current status of our regulation while I introduce you to a new legal proposal that we have seen in a draft version this summer. The proposal is yet to be presented in the Danish Parliament. We expect it to be this autumn. There's a political agreement behind the draft proposal, so we expect it to be decided perhaps with some minor changes. So that's the first point on my agenda. Second is criminalization and what activities are criminalized according to the Danish law. And last, I will touch upon the aspects of parenthood and recognition of parenthood where surrogacy is involved. And of course, there's a very crucial and central decision here from the European Human Rights Court, the KK and others versus Denmark from 22. And that decision was probably the reason why the Danish legislators began reconsidering this whole topic of surrogacy. But I commit myself to save this point for last because it's not directly related to criminalization, but as said, in relation to recognition of parenthood. So moving on to the current status in the Danish legislation, we don't have any comprehensive regulation of surrogacy. We don't have any criminal provisions applying to the mere role as a surrogate or as the intended parents. We have some criminal provisions that apply to certain activities, such as facilitating, advertising, and for medical professionals to assist in reproduction. And so far, the aspects of parenthood have been solved through adoption and stepchild adoption. And we have had a very strict administrative practice if payment had happened to the surrogate. So this is the current status. And what we see in the draft proposal for a new law, it is called Family Formation Through Surrogacy Agreements. It was, as I said, presented this summer. Well, it's actually a recognition of surrogacy as a reality. That's the opening line in the draft proposal. So that's a positive sign, we think. The proposal aims to improve the legal position of the child and the intended parents. And it introduces two tracks for early recognition of parenthood, either as a Danish altruistic surrogacy agreement or as an international surrogacy agreement. I will get back to these two tracks later on. But I will move on to the aspects of criminalization. As I said, there are no criminalization in place covering the mere roles as either surrogate or the intended parents. But we have some criminal provisions in place that apply to certain activities. First of all, we have this provision in the Adoptions Act concerning facilitating surrogacy agreements and advertising for surrogates or intended parents. The the purpose, if we look in the preparatory works from back then, it was enacted in 1986. The purpose was to keep surrogacy within the families. For instance, a sister could help out or keep it within the close friends. So that was the intention back then. Actually, this facilitating and advertising for surrogates or intended parents, that could also make the surrogate or the intended parents criminally liable. For instance, if a surrogate advertises for intended parents or intended parents advertise for surrogates. So they could be criminally held liable according to this provision. Well, it is interesting to notice that we haven't had any judgments so far. It was, as I said, from back in the 86, it was enacted. So we haven't seen any judgments on this provision so far. As concerns medical professionals, they are forbidden to assist in reproduction. And this provision was made back in 97, and it was very briefly mentioned in the preparatory works that it was just to align the medical professionals with the before mentioned provision in the Adoptions Act. So neither the medical professionals are supposed to facilitate and assist in these matters. And this provision is in the Assisted Reproductions Act. And both these two provisions, they can be punished with a fine or imprisonment for up to 4 months. So that's the same penalty for both of them. But also when it concerns medical professionals, we haven't seen any judgments. And I asked the ministry for any sanctions related to the authorizations of medical professionals, and there haven't been any sanctions related to this. So actually, both for facilitating surrogacy and also for the medical professionals, we haven't seen any judgments or any decisions on these two provisions. Well, if we look at the new proposal for law, as we have seen it here in the draft version in the summer 24, the aim is to actually continue this criminalization unchanged, despite there's no enforcement, despite we don't see any judgments or any activity in relation to prosecution on these matters. But what is to be noticed is that the medical professionals will still be held punishable for assisting in reproduction. And that's a bit strange, because we will be introducing a new track for Danish altruistic surrogacy, but the medical professionals in Denmark are not allowed to assist in these matters. I'll get back to that later. But we also have a new criminal provision coming up in this draft proposal, namely with the wording, after the pregnancy is established, the child must not be sold or bought with the intention that the buyer will raise the child as their own. And in the draft proposal, it is mentioned that we actually in Denmark need this provision to comply with international regulation on human trafficking. This is an error in our system that we haven't had this provision so far. But we can also see that it might now, if it's decided in connection to the rest of this legislation, that it might make an incentive to make sure to comply with 2 tracks for early recognition of parenthood. Otherwise, if you are too late, you risk a prosecution after this new criminal provision. So it's actually, it can work as an incentive to comply with the 2 new tracks. Yes, and then we have this very interesting decision. I think some of you might know it already, but I will briefly touch upon it. It was a decision from the European Human Rights Court back in 2022. The facts were that a Danish couple had made a commercial agreement with a surrogate in Ukraine, and 2 children were born. And the Danish genetic father was recognized as legal parent. The mother was the woman giving birth, that is to say, the surrogate. And the intended mother in Denmark was denied stepchild adoption because of payment to the surrogate. In Denmark, we had a very strict practice that if any sort of payment was involved, a stepchild adoption would be denied. We were corrected by the European Human Rights Court in this matter. The court said that the children were denied the recognition of a legal parent-child relationship with the intended mother, They had been living together in Denmark for several years. The relationship had become a practical reality. So that was an infringement of their right to family. Based on this decision, of course, Denmark had to change their practice on stepchild adoption. And of course, this decision also led to a wider reconsideration of the whole legislation concerning surrogacy. Well, the two new tracks, as laid out in the draft proposal, and I must say that it's not a law in Denmark yet, but as it is laid out in the draft proposal, we have these two new tracks. I will start in the left side with the Danish altruistic surrogacy agreement. There are some conditions that must be met. The surrogate mother must be at least 25 years old. She must reside in Denmark, and she must have given birth to at least one child. No payment must be involved, not even compensation for lost earnings or any kinds of payment. There must be a genetic connection between the child and at least one intended parent. So these are the basic conditions. Then there must be an agreement between the surrogate and the intended parents, and this agreement must be approved by the Agency of Family Law prior to the pregnancy. And then legal parenthood can be established at the time of the child's birth without the need for stepchild adoption. So of course, this will make an improvement of the legal status of the intended parent, that is to say either a mother, a male partner, a single parent, or two women. And also the genetic connection is not just the father, but it could also be the mother now. Well, that was the Danish altruistic surrogacy agreement. And then on the right side of this slide, I have the international surrogacy agreement. The conditions are here that one intended legal parent in Denmark is genetically connected to the child. Documentation with confirmation of the surrogate's transfer of parenthood and child to the intended parents is presented. The surrogate agreement is presented, and the agreement must be made before the pregnancy is established, and the surrogate must be resident abroad. And when a surrogacy agreement is approved by the Agency of Family Law, legal parenthood can be established at the time of the child's birth. So the aim of these two tracks is to improve the legal status of the child and the intended parents. Still, if you look at these two tracks, if the purpose of these two new tracks is to move some surrogacy agreements home to Denmark, well, we can see that there are some quite strict conditions for the Danish altruistic surrogacy agreements that are not in place for the international surrogacy agreements. First of all, we have the conditions for the surrogate in relation to age and previous birth, the requirement of no payment, and as said, it is still forbidden for medical professionals to assist. And in comparison, the international surrogacy agreement is literally without any conditions in comparison. It's more liberal, and it's actually a recognition of our legislators we can't control what's happening abroad, but we can have these documents in place, and then we can consider the child in that relation. So the result is that there are still very strict conditions for the Danish altruistic surrogacy agreement, and people might still choose the international surrogacy agreement because it's more liberal. So our points of attention, we prove that our legislators recognize surrogacy as a reality and try to cope with the realities. That's at least an improvement. But we find that the Danish altruistic surrogacy track is too narrow in comparison to having the surrogacy agreement happening abroad. It's also interesting to notice that we still don't allow any payment to the surrogate, not even reimbursements for lost earnings, and that might be too narrow. And still, it's punishable for medical professionals to assist in reproduction when Danish altruistic surrogacy is applied. And as a criminal lawyer, I'm still interested to know why would they keep some criminalization going despite the lack of enforcement? Why keep all these provisions in place if they're not being enforced? So these are our points of attention, but as far as Danish, the new proposal goes, many things can happen during this autumn, and we can have this new legislation in place. We can have changes or whatever, we'll see. It's supposed to enter into force the 1st of January, but let's see if that's realistic. Thank you.
Many thanks indeed. Perhaps now I can invite Dr. Silvola to take us to Finland with many thanks.
Thank you very much. Good day also from Finland. It's a great pleasure to participate in this conference, and thanks to Jens and Candy and Daisy for us to be in this beautiful venue. It's thank you for having us. Professor Katja Karjalainen and myself will present to you the Finnish take on how criminalization provisions work in our country. My friend and colleague Katja Karjalainen is a recently appointed professor in law and welfare at the University of Lapland. I is the full-time academic here. And as you heard from Joshua earlier, I work full-time as a civil servant at the Ministry of Justice in Finland. But since I'm here off duty, I decided that I'm participating in this conference in my private capacity, in my private academic capacity. So I'm using my academic credentials, and any views that I present here in this conference will be strictly my own views and not the views of the Ministry of Justice. The facts, naturally, will remain the same for both. So first, going through some general legal framework. And in the categorization of Jens and Claire, Finland belongs to the prohibitive countries. And that means that any medically assisted surrogacy is prohibited in Finland. There is a clause that says that as assisted fertility treatment may not be provided if there is reason to presume that the child will be given for adoption. And since we apply the mater semper certa est rule, which means that the transfer of birth motherhood can only happen by adoption, i.e. medically assisted surrogacy is prohibited in Finland. However, there is a little inch of tolerance in our country as well. Since non-assisted surrogacy there's no regulation about it, and hence it's allowed. Also, the international surrogacy arrangements are regularly recognized in Finland in practice, although they are always viewed case by case. So in those terms, you could say that there is some tolerance in Finland as well. The regulation is very much focused on legislation on assisted fertility treatments. I'll go through those provisions a little bit more later on. There are some aspects of regulation in the Parenthood Act and Adoption Act. In the Parenthood Act, there's the private international law provisions, and in Adoption Act, of course, the transfer of maternity provisions when surrogacy has taken place. Prior to the Assisted Fertilization Act, there were no regulation in the country, and at that time they did conduct some surrogacy arrangements in Finland, and not only for Finnish couples, but also other Nordic couples. They were performed for no profit. They were altruistic surrogacy arrangements. There were about 20 cases and 11 births, so very, very small scale. And then going into the criminal provisions, as I said, sanctions or regulation is very focused on healthcare professionals, not so much even intermediaries or intended couples, virtually none on the surrogate, because in the surrogacy arrangement situation, surrogates are kind of viewed as victims rather than criminal agents. But the primary provision on criminal provision on healthcare professionals is in the section 35 of the Assisted Fertilization Act, and it says a person who intentionally provides infertility treatment, even if there are reasonable grounds to assume that the child will be adopted, shall be sentenced for infertility treatment violation to or fine. So no jail sentence, but a fine. In effect, it's very effective, since no fertility clinic wants to risk their clinic license, and no healthcare professional wants to risk their own personal professional license. So there are administrative sanctions that have a kind of indirect effect here. You do risk also different other kind of administrative sanctions implied. In addition, there are clauses on illegal adoption in the criminal code. There is a clause prohibiting obtaining consent for compensation, consent for adoption for compensation, which includes maximum jail sentence for 2 years, and there is an illegal arrangements of adoption, which includes a maximum jail sentence for 1 year. However, as I said, there is appeal court case from 2013, a little bit of the same facts as the K case in Denmark, but the surrogacy arrangement had taken place in India, and when they were still allowed there. It was a case about whether the arrangement could be recognized in Finland, and whether it was against public policy in Finland. In that connection, it was said that consent for surrogacy arrangement could not be treated equally as consent for adoption. Therefore, this illegal adoption criminal code provision could not be applied there. Another provision that should be mentioned here is the registration offence. We take our registries very seriously in Finland, and it may be a surprise that the registration offence here has a maximum jail sentence for 3 years in comparison to these other criminal provisions. It applies if you provide false information to a public register, including information on parenthood. And Katja continues from here.
From consequences of those provisions that Salla kindly explained to you. Okay. Well, we have come to a conclusion that criminal behavior of intended parents does not affect the formation of parenthood. It is quite obvious from the Finnish provisions. We follow mater semper certa est principle. Giving birth is the essential issue in establishing motherhood. We follow pater est principle. If parents are not married, in these cases, consent to paternity or, well, in second maternity also is important, or the prevailing factor. As well, if there is assisted fertility treatment behind the child, consent to this assisted fertility treatment is the one that determines the second parent. Genetic motherhood does not, in principle, play a role in establishment of the parenthood in Finland. Adoption process is basically always needed to establish parenthood of the intending mother in surrogacy cases. In some cases, parental responsibility rights are given to the mother prior to the adoption taking place, and in these both cases, the best interest of the child is the principle that it is used when assessing this in the courts. So that's how the parenthood is formatted. Criminal behavior does not have an effect on the formation of parenthood, and we try to figure out whether this criminalization that Salla explained actually has some certain role in practice. And we have, or Salla has recently checked from the National Supervisory for Welfare and Health that there actually are no breaches with respect to act on assisted reproduction. So medical professionals follow the rules that are set by the legislature, which is of course good. There are two cases that we found that are relevant in this framework that we are discussing today. One was an investigation of the registry breach of registry office. Sorry, office. That's true. And in this case, intended parents had informed that they're both biological parents of the child, but in fact only the brother was genetic parent of the child. So so this went to the court, and parents were considered to breach the law, but they were not convicted because or they were not punished because the crime was considered so minor. And by that time, the maternity was also established through intrafamily adoption. So, and then there is another case which is actually maybe even more interesting, but we do not have yet all the facts. But we know that the police department in Finland is actually currently investigating a case in which a case of some sort of domestic surrogacy, whose genetics are used, we do not know yet. But in this case, the intending parents had made a contract with the surrogate so that the surrogate would give up the baby after the baby is born, and she will be compensated. Well, the surrogate wanted to keep the child, so these intending parents went to the police department to have the agreement to be fulfilled. Well, what happened was that police started an investigation on illegal consent to adoption, because you cannot consent on this kind of issues in Finland. But we will most likely be in the nearby future wiser. what will happen with this case. And to conclude, we actually have to say that this domestic sanctioning of surrogacy works relatively well, because we do not have cases. Medical professionals follow the rules, as the professional risks are high. And then, on the other hand, as the domestic surrogacy is prohibited in Finland, Finnish authorities cannot give advanced guidance to those who would like to resort international surrogacy arrangements. So this domestic prohibition kind of creates social and practical obstacles to resort. And this works in Finland because it is a society of kind of high trust to authorities still. And so their guidance is generally followed. And then we were actually contemplating what would happen if we would allow domestic medically assisted surrogacy. It would basically mean that authorities should give advice also to those who would like to resort to international arrangements. And then would it actually increase the number of those going abroad? Because domestic criteria would anyway be subject to quite strict eligibility assessment, and the healthcare would have scarce resources to provide domestic arrangements. Would there be enough domestic surrogates? So, yeah, this is an issue that must be taken into consideration when contemplating lifting up the domestic surrogacy ban. But anyway, to conclude, we argue that addressing domestic and international surrogacy should be sort of addressed. Well, they have to be addressed at some point, but maybe ideally the international regulation would be enforced before lifting of the domestic regulation, because it would open the gates maybe to international arrangements. And of course, on the other hand, if we would join, for instance, the Hague Conference instrument on entailing parenthood of children born under surrogacy arrangements, or the EU parenthood regulation would go forward, it would not be very sustainable in a way that we would have domestic prohibition for something that we would basically allow in international framework. Thank you.